Case number C-17-141, State of Washington versus Donald J. Trump.
The order is illegal and is causing serious immediate harms to our states, to our state institutions, and to our people. And enjoining the order is overwhelmingly in the public interest. I'm not aware of any executive order quite like this one, that there's so much evidence before there's even been any discovery that it was motivated by animus, religiously targeted, and just utterly divorced from the stated purposes of the order.
It seems to me that it's a bit of a reach to say the president's clearly anti-Muslim or anti-Islam based on what he said in New Hampshire in June.
We have the president's advisor saying on national television that the president asked him to come up with a Muslim ban. This was after the election. Asked him to come up with a Muslim ban in a way that would make it legal, and that's what they did. And so
does the executive order mention the word Islamic or Muslim?
It does not. But when we're arguing about religiously motivated targeting, again, the burden is not to prove that it affects every single person of the Islamic faith. The burden is to prove that a desire to discriminate based on religion was one motivating factor in the adoption of the order. Part of the evidence of that, Your Honor, is that the tie to the stated purposes of national security is so tenuous here. I mean, the president apparently had not decided whether the order applied to lawful permanent residents before it was issued. And there's roughly 500,000 lawful permanent residents from these 7 listed countries in the United States. Either those people are an enormous threat to our safety or they're not, and they've changed their mind about that 5 times since Friday. First they said that it did apply to them, and many of those people were excluded from returning to the country. Then they said, and the Department of Homeland Security reiterated that it applied to them. Then the Secretary said that it didn't, and then the White House spokesperson said it did not, and then the White House counsel has now issued authoritative guidance, whatever that means, that although there could have been reasonable confusion about what the order meant, it wasn't meant to cover those people. So the point is, if they were an enormous security risk, you would think that they would have made up their mind about that before issuing the order.
Your Honor, for some of the reasons we mentioned, we think we have very good reasons why the state is not likely to prevail on the merits, but I'd like to start with standing, which I think distinguishes this case from some of the other cases that have been filed around the country.
Let me stop you. In the state of Washington, I can't speak to Minnesota, but both the University of Washington and Washington State are considered parts of the state government, and they've cited a litany of direct consequences, damages to them. Given the breadth of authority of the executive in the area of immigration, do you acknowledge any limitation on his or her power?
Your Honor, I don't think Your Honor needs to answer that question to decide on this case.
No, but it seemed like a good question.
Given, I don't think it would be wise to sort of opine on what the extent of the executive's power is. I mean, I think here we have specific circumstances where the president has issued this executive order. It was pursuant to authority that Congress gave him in Section 212F of the INA that specifically allows him to suspend the entry of certain aliens or a class of aliens when he finds that it would be detrimental to the interests of the United States to allow them in. So here we have the president acting pursuant to power that Congress gave him, which means under the Youngstown still seizure cases, he's acting at the apex of his power.
The court finds that for purposes of the entry of the temporary restraining order, that the state has met its burden of demonstrating that it faces immediate and irreparable injury as a result of the signing and implementation of the executive order. I find that the state has satisfied the test that it is likely to succeed on the merits of the claim which would entitle them to relief. I find that the balance of equities favor the states. And lastly, I find that a temporary restraining order is in the public interest.